This is the Utilities Committee, and we are going to open a hearing on HB 2109. This is authorizing public utilities and law enforcement agencies to enter into a utility pole attachment agreements for the installation of law enforcement equipment on structures located in the public right-of-way and exempting public utilities for liabilities relating thereto. So first one up is Mr. Nick Myers, Assistant Revisor, Office of the Revisor of Statutes. Good afternoon, Nick.
Good afternoon to you, Mr. Chairman, and to you all too, committee members. So committee, as the chairperson said, House Bill 2109 relates to attachment of law enforcement equipment on utility poles within the public right-of-way. So this bill would require any public utility, this would include any municipal utility or cooperative utility, in addition to the IOUs, the investor-owned utilities, to enter into a pole attachment agreement with a law enforcement agency upon request of the law enforcement agency. This pole attachment agreement would then allow and authorize the law enforcement agency to attach and operate law enforcement equipment, is the term that's used in the bill, on utility poles, as I said, in the public right-of-way. So the bill would require, upon that request made by a law enforcement agency, the utility to enter into a pole attachment agreement. And this pole attachment agreement would be required under the bill to identify the utility poles where that equipment may be attached, specify the nature and a description of the equipment that would be attached, establish safety specifications for attachment, access, operation, and removal of the law enforcement equipment. The agreement would have to grant the utility the sole discretion to require that the attachment and the access, the operation, and removal be done either by the public utility or by a contractor who is qualified for that work, who should then be approved by the public utility. So in other words, the utility has discretion to establish who is going to be working on the utility poles to attach the equipment. And then lastly, it would require the law enforcement agency to indemnify, defend, and hold harmless the utility from and against all liability relating thereto. So just a few things relating to this bill. So this bill would authorize the utility to assess reasonable fees and charges to the law enforcement agency to recover actual costs incurred by the utility for any work relating to the attachment and operation. It would prohibit a utility from charging or renting the space on a utility pole. So it's just for reasonable costs that are incurred by the utility for the attachment. The law enforcement agency under this bill would be required to warrant and guarantee that the attachment and operation of the law enforcement equipment complies with applicable laws and regulations relating to that law enforcement use of the equipment. And additionally, the bill does state that the law enforcement agency would be the sole entity that's responsible for determining whether there's a need for a court order or a warrant relating to that law enforcement equipment's use on the utility pole. With regard to liability, as I said, a law enforcement agency would be required to indemnify, defend, and hold harmless a public utility under the bill for all claims or court actions arising pursuant to that attachment and operation, and then also any damages that are incurred upon the utility system or infrastructure that's caused by that equipment being attached to the utility poles. Lastly, with regard to liability, the bill does state that if a public utility enters into a pole attachment agreement, that public utility would be considered an instrumentality of a governmental entity under the Kansas Tort Claims Act, and then entitled to all limitations on liability provided therein. And Mr. Chair and committee members, I have some of the defined terms in the bill at the last page of my memo. Those terms are also in the bill itself, and you can read through those as to the application of the bill. And one final note, if this bill is enacted, it would take effect on July 1 of 2025. I think my memo has a mistake there with 2024, but this would be July 1 of 2025 upon publication in the statute book. And Mr. Chairman and committee members, I'd be happy to stand for questions.
Okay, good job, Nick. Committee, we have any questions for Mr. Myers? Okay, thank you.
You're welcome.
Okay, proponents,
Thank you, sir. I appreciate it. Mr. Chair, committee members, thank you for your time today and allowing me to testify on behalf of this bill. My name is Jeremy Knoll. I'm a deputy with the Sedgwick County Sheriff's Office. I'm in my 24th year of law enforcement. But today I'm testifying on behalf of the state of Kansas Fraternal Order of Police. We represent over 4,200 law enforcement officers across this great state. The little bit of a story about me to lead into why I'm here to testify today. And the chair told me I had a half hour to testify. So I started my law enforcement career in Beloit, Kansas on December 12th of 2000. It was Christmas, and the city, they decorate their city park with all kinds of Christmas decorations every year. Beautiful. Well, I'm a new cop, and we had a bunch of vandalism in the park. Somebody was coming in at night and destroying a lot of the ornaments. I was the youngest and the skinniest at the time, and they said, hey, we want to put a camera on a utility pole that's close to the park. We didn't have enough manpower to put somebody in the park at night, so this was the next best idea. So we backed up a truck to a pole, put a ladder in the back of it. I shimmied up the ladder, and then I hung on for dear life to this pole. And we put the camera on it, and we left it there overnight, and the next day we went back and got it. And lo and behold, there were images of some teenagers coming into the park. We got them identified. Anyways, I tell that story because this is not new technology. This is not something that we're recreating, and you can actually replace that word vandalism with the word drug activity, with gang activity, with major crimes. This bill is something that is going to protect those utility pole companies that we ask for help from. And this bill will protect them from any kind of civil liability that may fall upon them. We can also use their existing infrastructure, just like we did in Beloit, and we don't have to put up new poles. There's no additional cost to the citizens, to the taxpayers. We're going to already use equipment that's there and it's in place. I'm going to cut myself short today. So I appreciate your time. And for these reasons, that's why we ask you to pass House Bill 2109. I'll stand for any questions.
Okay, thank you. Committee, we have any questions for him? Senator Peck.
Thank you, Mr. Chairman. When you were on that ladder hanging on that pole, is that what caused your beard to turn gray?
Yes, sir. I believe that's when it started.
Okay, that's good to know. I was just wondering, because that was the same way with me. But other states have this kind of legislation or law on the books?
I believe so. I don't know of any specifically, but I believe there are some.
A really good answer.
No, it's not. I wish I had a better answer for you.
Well, I trust that maybe research or someone can get us an answer, but a lot of times, if other states have already done something, we can learn from their errors. And so as far as the cost, it would be borne by the law enforcement agency putting up the camera or the equipment. Could it be used by other, I'm thinking in local area, Montgomery County Sheriff's Department, Independence PD, can it be used by other law enforcement or just the law enforcement agency that installed the camera?
It can be used by, so if, let's say we put up the camera, we entered into the agreement, we put it up, we could share that information with other agencies.
But they wouldn't have access to it without going through you?
Correct. Yes, sir.
Thank you, Mr. Chairman.
Senator Bowers.
Thank you, Mr. Chair. And Jeremy, thank you. I like your bill. I just want to give a shout out to Senate District 36 where Beloit is.
Okay, great.
So thank you for saying that. And it is a beautiful park. You were so right. Thank you.
Senator Bowers wasn't on that camera, was she?
No, sir.
Any other questions? Okay. All right, Jeremy, thank you very much.
Thank you.
Okay, next we have Ed Klump, Legislative Liaison, Kansas Sheriff Association, Kansas Association of Chiefs of Police, Kansas Police Officer Association. Welcome to committee, Ed.
Thank you, Mr. Chairman. I'll save myself repeating all that. You did such a good job on it. I am Ed Klump, though, representing those associations. We very much appreciate the opportunity to present to you today on this very important bill. Any of you that came to our reception in January, you might remember this is one of our priority bills for this year. One of the few. We don't have the long list we've had in the past 2 or 3 years, which I was glad to see. I want to start out with just making very clear what this bill is about. This bill is all about the liability that may fall on the utility company when they allow us to mount these cameras, and to put that liability where it belongs, which is with law enforcement who is requesting them to assist us. Utility companies have been very good community partners in many, many ways, and they're trying to help us in addressing crime problems in our community. It's good for them, it's good for the community, it's good for their customers. And so what has happened is, over in Missouri, one of the utility companies got involved in a lawsuit that was filed by someone who was objecting to something that the law enforcement agency had done in the use of the video system. And that was the allegation, but they named not only the city or the law enforcement agency, they also named the utility company. And as a result, utility companies are hesitant because although that was defensible, you know what it costs to defend in a lawsuit anymore. And so they became hesitant to allow us to put these cameras on the pole. Now today, we don't climb the pole and hang on for dear life. We have the utility company or somebody they agree as a contractor to do that. Thank goodness I never was asked to climb a pole and put one of these up. So that is what this is all about. So for 30 plus years, we've been using these devices on poles. I don't know exactly how many, but I know we were using them when I was still on the street at the Topeka Police Department. I've been retired quite a few years now. And I want to tell you one story real quick about a community thing we had happen. We had a 2-block area just east of downtown, just southeast, that was 60% owner occupied. You would not know it by driving down that street because you would never see anybody come out of the homes. You would never see anybody plant flowers. You would never see people painting their houses. It looked like a desolate landlord slum area. The problem was drug dealing. There was heavy, open drug dealing going on in that area, and everybody was afraid to come out of their homes. Through the use of one of these cameras, we were able to monitor that activity, identify the people involved. We were able to understand what times they were usually out there doing this activity and how they were conducting that activity. And that gave us all the information we needed to plan an activity over a period of several days where we would go and we would actually make buys when we could. And when we couldn't, we would swoop in and we would catch them with drugs. Now, drug dealers aren't stupid, totally. They would take and they would go in their house, they would bring out a handful of dope, they would sell it, then they'd have the money in their pocket, right? Then they'd go back in the house, they'd put the money up, they'd come out with another handful of dope, and that would go on 10 or 12 times during the course of their business hours. And so if you caught them, you didn't catch them with the money in their pocket or the very much dope in their pocket. That's the way they worked. That operation was successful. We flushed those drug dealers out of that area. And within 12 months, those houses were painted. There was flowers growing in front of them. People were sitting on their front porch in the evening. That's the difference these things make, that we use as tools to address those community and neighborhood issues. That's why they're so important to us. We agree that the utility company should not be subject to these lawsuits for something somebody wants to allege we did, and that's what this bill is about. And we are in absolute agreement with that. If you look on page 1, starting on line 913, you see those 5 items that the reviser talked about. And I want to point out 2 in particular. Number 3 has to do with the utility company establishing We don't establish it. They establish what their safety and security standards will be to mount these cameras. They are in control of their security and their safety for their workers. And then number 5 is the indemnity provision that the revisor pointed out. The other thing I want to point out about these cameras is we put them up when we have a reason to have them up. We don't put them up and leave them for long periods of time. That operation I talked about, I think we had it up for about a week. Once that operation is over, once that need is gone, then we have the utility company take them back down. So we don't put them up, leave them up. These aren't long-term things. These are pinpoint applications to address a particular problem, whatever that problem may be. There is well-established case law on when we have to get a search warrant when we put one of these up and when we don't. And we err on the side of caution. If there's any question we may need a search warrant, we'll go get a search warrant before we put them up. And that's not that difficult to do. So you kind of heard what all we use these for. I want to add one more. I think it was last year that many of you were getting letters with powder in them, and we used law enforcement. I don't know whether you were aware of it or not, but there were several of you that had activity going on around your house that was concerning that we use this type of device to monitor that activity in front of your homes. So those are the kind of things. Something comes up like that, we have a benefit to using these. That's when we put them in, and then when that's over, we take them out. Please help us do the right thing for our utility companies, cover them on this so they can help us do our job and keep our communities safe. Mr. Chairman, I'll stand for questions.
Yeah, thank you, Ed. Very good. Committee, we got any questions? Yes, Senator Thompson.
Thank you, Mr. Chair. Thank you, Ed. With regard to these poll agreements, you said it was pinpoint, but I mean, do you do it like if you have a city, can you get an agreement for all the polls within a certain area, or are you just picking your prime spots? I'm just kind of curious.
I think this is going to be point by point. I think we'll have to have one of these agreements for everyone every time we put one up.
Each poll, basically.
Now, understand that we'll be dealing with the same utility company, you know, and we'll have those things worked out. So it'll be a smooth, quick process. But I think the way I understand these agreements, they would have to be unique to each situation because of different safety concerns that may come up in situations like that.
Okay.
And then it also places the responsibility on law enforcement to make sure we're putting them up legally and abiding by all the case law.
Within a time frame and,
Right.
and how long,
Right.
everything. Yeah.
Mhm.
All righty. Thank you, Mr. Chair.
Senator Holscher.
Thank you, Mr. Chair. Thank you, Ed, for being here. I do have 2 different questions. You started to allude to the time frame that these cameras aren't there indefinitely. What is the typical time frame?
Well, it varies. It depends on what the issue is we're looking for. For example, with the legislators that those were used at, we wouldn't take them down until we were comfortable that whatever was happening was done and no longer a threat to you. If it's a drug operation like I described, it depends on how quickly we can get the situation resolved. And then we would take them down. I did one where we had a very serious complaint that was based on some people that weren't ultimately responsible for anything. It was really a domestic violence situation that the attacker forced the victim to say that it was other people that did it. And we had uncovered in our investigation that that was true. And then the victim and the accuser, or the suspect that assaulted her, came up with these stories about how these same people were coming over to their house periodically and doing damage to the home and doing different things. We put a camera up to record the front of that house and was able to verify without a doubt that their reports to us were false because we had the video showing that at the time they said these people came over, they came out on their front porch and caused the damage and then went back in the house and called us. And so those are just some of the oddball things that we get that we use these. But it depends on the event and what we're trying to cover and how long the activity is going on.
I have a second one, if I may, please. I understand, too, the intent of the bill is to exempt the public utilities from civil liability, but does this still allow for potentially workers of utility companies to be subpoenaed?
I have never heard of a case with a utility company worker being subpoenaed because all they are doing is mounting the camera. It would be no different than if we did a wiretap. They don't subpoena the people that are doing the wiretap technology. They subpoena the people who are accessing the data. And they're not going to be able to access the data. So I've never heard of a utility company getting subpoenaed on these.
Thank you.
Committee, any other questions? Senator Peck.
Thank you, Mr. Chairman. Mr. Klump, you mentioned monitoring activity outside of legislators' homes. Where I live, that could be a dangerous thing for anybody to be monitoring anything because of being remote and secluded. And there's lots of questions I could ask, but I'm going to just ask one for now. What about the people who will say something to me about invasion of privacy, illegal search, illegal videoing?
So here's the three basic rules. The basic rules are if we're looking at things that are in the normal view from public access space, in other words, from the street, sidewalk, places where anybody can walk, then we don't need a search warrant, okay? If we are looking at things in an area that you couldn't normally see from those points, then you need one of two things. You need the property owner's permission, or you need a search warrant. So that's how privacy is protected. It would be no different than if we got a search warrant to go on a piece of property looking for evidence of a crime. We would have to show cause to the court that we had probable cause illegal activity was going on, and that this was a tool we were using to identify the suspects or gather evidence for that crime.
You wouldn't have probable cause without the camera. Correct?
No, you would have probable cause because we have, you know, take the case of the narcotics thing. We've got people telling us what's going on. We have made buys down there. We know there's illegal activity going on. So if that would have been a case where we needed to get a search warrant, which it wasn't, we could have gotten it because we had probable cause to believe that crimes were being committed. And so we could gather evidence in the investigation of that crime. And we frequently get those warrants.
Thank you, Mr. Chairman.
Senator Warren.
Thank you, Mr. Chair, and thank you, Mr. Klump, for your testimony. It's interesting to see our law enforcement friends who are usually conferees in Judiciary Committee here in front of the Utilities Committee.
I have been in front of a wide variety of committees this year. It's been an unusual year.
Yes, I have noticed. But it sounds like this bill is mostly about law enforcement, crime, lawsuits, liability, those type of issues. What happens if the energy company doesn't want to negotiate, doesn't want to enter into one of these agreements? Can the law enforcement entity override that and attach the cameras anyway?
Well, no, I don't think we could, especially with this law on the books, because it requires us to enter into an agreement to do that. It also requires the utility companies to enter into an agreement. And I think there's good reason for that. And in fact, I had a person from one utility company, I don't want to speak for them, so I won't say who it was, that told me they liked the idea of the requirement because then when their customers complain, they can say, hey, look, we have to cooperate with law enforcement to do this.
So we're by law mandating that private corporations agree and they have to enter into a private contract with law enforcement.
That is in here, yes.
That's what the bill does. It would mandate that. And then with the cameras and when they're on, I don't know what the warrant looks like, but are the warrants specific enough that it's, this time of day, or is it on, 24/7, and you happen to see another crime, which
Well,
you wouldn't have been able to get a warrant for because you didn't have any reason to suspect that person was engaged in activity, but you are on camera having been caught because the camera's been placed there looking for someone else.
so it's a search warrant. It has no spatial rules to it than any search warrant has, which we have a given amount of time to serve a search warrant. If we don't, we have to return it to the court that it was unserved.
And when you say serve one of these search warrants, is the search warrant, we have a search warrant to place a camera on this utility pole at this
So
location for
the
this
service is
time,
placing the camera on the pole.
but not looking for a specific person, just to observe the premises?
We would have to have probable cause that a crime is being committed, that we have probable cause of crimes being committed, and that it's being committed on that property in order to get a search warrant. And
don't have
that's
to
no
name a
different,
specific
no,
person.
nor do we have to in any other search warrant.
And so CURB has raised some concerns in their neutral testimony that's been submitted. CURB notes the potential for conflicting interests of maintaining the integrity of the utility system and the needs of law enforcement to install equipment. It's unclear how this tension is resolved and whether the KCC has a role regarding the utilities it regulates. Can you talk about that a little bit? Have you looked into potential conflicts?
Nobody has mentioned that to me. I have not seen the testimony. It's the first I've heard of that concern. But I would point you to number 3, line 21 on page 1, that allows the utility company to establish the safety and security specifications. And so I would think that would be part of the project. That's the intent, is the utility company still has a say of what can be done on their pole. And you'll notice that we have to provide certain information about the actual camera device. I think that's in number 2, about size, weight, and things like that. So if that's a concern that would interfere with their equipment, their lines or anything, then they can address that with us in that agreement.
So if you've got this agreement and it's a written agreement and there are disputes, it's a contract at that point, and there are disputes, what entity would have the authority to resolve the dispute?
I can't answer that. I don't know. But I can't imagine a scenario where we would actually not come to terms with the utility company, even if that meant, okay, this isn't going to work at this location because of your safety concerns or because of this equipment won't work on that pole.
But aren't they mandated to enter into the agreement?
Well,
Just playing devil's advocate.
Yeah,
Because
yeah.
I could see these situations. We've got a lot of utility poles across the state and lots of different
So-
needs for law enforcement. And when those
So I
don't
guess-
align, what happens?
I guess this kind of circles around to when does shall mean shall? And of course, the courts have ruled that shall means shall when there's a penalty involved. There's no penalty in this if somebody doesn't comply. So, must is used as in those statutes more or less as a strong statement of the intent. But if there's no penalty and there's no provision of challenging that to any court or anything like that, I think we would just have to say, okay, then this isn't going to work in this location. I mean, our relationships with the utility companies has always been strong. They're usually our local utility companies that we have, relationships with already. And I just can't imagine that we're going to say, no, by golly, you're going to do this if they have those kind of concerns,
Thank you, Mr. Chair. Do other states have this kind of?
I do not know that. I have not researched that, so I don't know. I don't know if other states have had this issue that we're facing right now where you had a lawsuit occur that had nothing to do with the actions of the utility company, and then they're having to defend themselves. And then the utility companies in turn say, wait a minute, we're going to have to give a hard look at all these when you want to do them. And that's what we're trying to address.
Okay. Thanks for the indulgence, Mr. Chair, and thanks for your testimony and the answers. So it's lots of questions, but thank you.
Committee, any other questions? Okay, thank you, Ed.
Thank you.
I would point out you got neutral written. Joseph Astrub from Curb. Joseph, would you want to say anything about that last subject that you had in your neutral? I'd be happy to let you say something there if you wanted to.
Thank you, Mr. Chair, members of the committee. My name is Joseph Astrub, Consumer Counsel with the Citizens Utility Ratepayer Board. Curb's been a neutral testimony in this because we acknowledge that this is a policy call, and we believe that law enforcement tools that are used to improve their effectiveness are important for the community. Position best left to legislature versus the regulatory itself. The purpose of my testimony is to hopefully point out some issues and concerns regarding the language of the bill and how it might play out. I'm a lawyer by trade, obviously, so we're always here to muddy the waters and ask those really tough questions. And I have a transactional law background, so contracts are kind of my thing. Well, what happens in this bad scenario? So, at the end of the day, when we have a good group, we hope that all the parties are satisfied and there's no issues. But that's just not the reality of things sometimes. So there may be those kind of off-beat situations where there's a conflict between the utilities' ability to install such equipment versus law enforcement. So, in my review of the bill, I'm quite sure whether that's a civil action that needs to be resolved by the court, or, for example, in the case of a jurisdictional utility, it's brought before the ks.gov. I think I will note one of the definitions in the bill, utilities also applies to cooperative municipalities that are not subject to the ks.gov. And so one could presume that that might be a court issue. But again, typically just my interpretation of the bill, the shallow there seems to imply that there is a requirement that if a law enforcement agency makes a request, utilities can do something to comply. So that could create a potential imbalance in negotiating the terms, the services, and everything too. I was bringing it up to the point to the committee to make sure that, hey, if we go forward with this, that the utility's not incurring additional costs that would normally incur in a more kind of level playing field where these agreements are voluntary and the utilities have discretion to enter into them or not for temporary purposes.
Okay, thank you. We also have a written neutral. Laura Lutz, Director of Government Affairs, Evergy, is neutral, and Catherine Magnana, a Legislative Policy Analyst for KDOT. So we have no opponents that I'm aware of. Is there any opponents here? Is there any other proponents? Any other neutral testimony? Okay. If not, we'll take and close the hearing on HB 2019. And what I would like to do at this point is work on final action for HB 2110. We got somebody here in the audience, so if we could have Nick kind of come up and give us an update on that, I'd appreciate that.
Yeah, I'll just update you all from back here if that's okay, Mr. Chairman. So, Mr. Chairman and committee members, House Bill 2110, as you guys are looking through your packets for it, to refresh your recollection of this bill, this is the bill that would amend the Kansas 911 Act. And generally, this is a follow-up to the 911 Act revisions that were enacted by the legislature last session. So this bill would remove the requirement that the 911 Coordinating Council, soon to be the State 911 Board, contract with the Local Collection Point Administrator, or the LCPA, for services. This would reschedule when the funds should be established in the state treasury, and then also reschedule when all the funds that are currently held outside of the state treasury shall be transferred into those new funds in the state treasury. This bill would require an immediate transfer of $1 million on July 1, 2025 into the State Operations Fund for operational use by the State 911 Board. This would also authorize the State 911 Board to make discretionary annual transfers out of their operations fund into the State 911 Grant Fund for any unencumbered monies that are remaining in that fund. And then it would also, if you recall during my briefing, remove that fee transfer cap that occurs on the state 911 grant fund. So that 1 cent of every 911 fee would be remitted to the grant fund without any a cap on that transfer. And Mr. Chairman and committee members, I'd be happy to answer any questions.
Okay, thank you, Nick. Any questions from the committee? Senator Francisco.
So I apologize for this, but I do note that this is on page 8, lines 40 to 43, that we're eliminating the description of how PSAP funds, or how the funds are divided if there's more than one county. Is that, and maybe Sherry Massey could help me if the revisor can't. I just want to make sure how that is identified without that requirement.
There to go. So this was actually a clarification. The removal of this language was clarification. Previous to HB 2690, thank you very much. Previous to HB 2690, all of the provisions that you're looking at in that little section, everything from line 35 down to line 43, were part of a single paragraph. So it's very clear they were all talking about the minimum distribution. 2690 broke it out into separated paragraphs that added some obfuscation, if you will, to the meaning there. And so removing this language is just to be sure it is understood that this only applies to minimum distributions. It's something that has never happened in the past, and that the council can handle on a case-by-case basis should it ever come up. But it removes the ambiguity created by having this language broken out by itself and then in conflict with language later in the bill.
Thank you. I knew that there was a reason to do it, and then I just went, oh, I was reading it over again, and I went,
Yep,
thank you.
certainly.
Committee, we got any other questions? Okay, thank you. So what is the will of the committee? Senator Pack.
Thank you, Mr. Chairman. I see some date changes in the legislation, specifically on page 13. It's changed from July 1, 26, or I'm sorry, January 26 to July of 25. Same thing on the next page, and then the next page. To give you an opportunity to converse with the House, unless you have some other plans, Mr. Chairman, I would suggest that the committee go back to the original January 1, 2026 dates. So that would be a conceptual motion amendment, and I see it as fairly simple, so I didn't get any revisor to do that, because I think the committee can understand that we would go back to January 1, 2026, striking July 1, 2025 in those three places.
Okay, thank you. Is there any questions, Senator Pack, on that amendment?
It would be a motion if,
A motion,
if you're
yeah.
willing for it to be a motion at this
Yeah,
time.
I am. So that motion, is there a second to that? Any discussion? Senator Francisco.
Well, I hate to have the Senate be the one that has the bill that doesn't make sense.
Oh. Okay. Is there any other discussion?
So
Go ahead, Nick.
the one thing that is occurring in this bill is that $1 million of the is being transferred from the operations fund that's currently outside of the state treasury. And you see that on the bottom of page 12. The operations fund transfer into the state treasury operations fund technically needs that fund to be created within the state treasury. And so at least for section 12, the operations fund, if that transfer will remain, that needs to be established and retained within the state treasury on July 1, 2025, since the transfer occurs on that date as well. Unless there was a will to change that transfer date, but I don't know that that would make much sense since all the funds will be transferred on that January 2026 date.
Senator Peterson.
If we just want to get this into conference, we could always make it effective upon the register.
Senator Francisco.
If that's a substitute motion, I would second it. And I think it's because we could then even discuss whether having it in the register would help the transfers on July 1st, 2025, which I think would be an interesting discussion to have.
I think that is a substitute motion.
I got a substitute motion by Senator Peterson. Do I have a second?
Second?
Senator Francisco seconds. Any discussion? All those in discussion?
Yes, thank you, Mr. Chairman. So sorry, I couldn't hear down here at my age. I was having trouble. So I'm to understand that the change or the motion is to change the effective date from statute book to register. Is that correct? Thank you, Mr. Chairman.
Any other questions? Okay, all those in favor of the substitute motion signify by saying aye. Aye. Those opposed? Motion carries. Okay, we're back on the bill then. I'd entertain any motion on that. Senator Francisco.
Thank you, Mr. Chair. I would move that we pass out House Bill 2110 as amended, favorably for passage.
Okay, we have a motion. We got a second. Is there any discussion? Okay, all those in favor signify by saying aye. Aye. Those opposed? Motion carries. Okay, thank you. And I think, let's go ahead and work on final action for, there's another one out there. This would be HB 2040. I'll give you a moment to get your file out. So, Mr. Myers, could you give us a little briefing on this one, please?
Certainly, Mr. Chairman. So committee, this is the bill you've seen multiple times. This is House Bill 2040. This is relating to transmission line permits issued by the Kansas Corporation Commission. And if you recall, this is the bill that currently in statute, the Kansas Corporation Commission is required to issue a permit after they receive a transmission line siting application within 120 days after receipt of that application, and this bill would extend that deadline to 180 days. And I'd be happy to answer any questions.
Do we have any questions for Mr. Myers? Okay. Thank you, Nick. So what is the will of the committee on this one? I think we have an amendment on this one, don't we? Yes. Senator Peterson.
I think we'll try a repeat of a sellout. Let's change the effective date to the register instead of statute book. So make that as a motion.
Okay, we got a motion by Senator Peterson. Do we have a second? Got a second, Senator Thompson. Any discussion? This is on the amendment now. All those in favor signify by saying aye. Aye. Those opposed? Motion carries. Okay, we're back on the bill then. We have any other questions about the bill? Okay, I'd entertain a motion on that. Senator Thompson.
Thank you, Mr. Chair. I move that we pass out Senate Bill 2040 as amended favorably.
Thank you. I got a second by Senator Peterson. Any discussion? All those in favor signify by saying aye. Aye. Those opposed? Motion carries. Okay, thank you. So there'll be two of them going to the floor. Do we have anything else for the committee at this point? Senator Clifford.
Just wondering when we might readdress the budget items we discussed yesterday.
I think that's on the agenda for tomorrow.
Okay, thank you, Mr. Chairman.